Oh yay, oh yay, oh yay. The Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Thank you. Thank you, Ms. Peoples, and good morning. Welcome to the Tennessee Court of Criminal Appeals December session. Prefer in-person hearings in the courtroom, but in the interest of operating and keeping the wheels of justice turning during the COVID pandemic, we are doing a Zoom session today, and we are very grateful to the AOC and to our clerk, Jim Hivner, for making it possible for us to do this, to use this technology to continue our judicial process during COVID and operate in a safer, probably the safest possible environment as far as stopping the spread of the virus, at least in the courtroom. So we're happy to be here. That being said, the procedure today is very similar to what we would do, if not exactly what we would do if we were in the courtroom. Let me introduce the panel to your I'm from here in Nashville, Davidson County, Tennessee. Each side will have 20 minutes to argue. If the appellant wishes to reserve some time for rebuttal out of that 20 minutes, if you'll notify me when you start, I'll be happy to try to keep up with the time for you. We have read the briefs, so we're prepared to hear the arguments. We have not looked into the actual records of the cases, but we will be doing so, of course, as we usually do after argument. And I think that's all of the preliminary matters I need to cover. So, Madam Clerk, when you're ready, if you'll just call the first case on the docket today, please.
State of Tennessee versus Craig Dagnan.
Good morning, Your Honors, and may it please the court. Brennan Wingirter with the Appellate Division of the Public Defenders Conference, here on behalf of the appellant, Mr. Craig Dagnan. Judge Wiedemeyer, if I could reserve 2 minutes for rebuttal, please.
Certainly.
Thank you, Your Honor. I'm not sure if Your Honors watched the live streaming of the or the recording of the arguments in Jackson on Friday, but I think it is safe to say that this court is now very familiar with the arguments that our office has been bringing in these probation revocation appeals. And I just wanted to start by saying that our intention is not to bring any frivolous appeals. Our intention is certainly not to frustrate or belabor this court by continuing to bring these probation revocation appeals. We are here because in my office, we are appellate attorneys second, and we are public defenders first. And our clients, at least on paper, have a right to appeal from an order revoking their probation. And my colleagues and I will continue to advocate for clients in these probation revocation appeals until either this court starts denying our requests for oral argument, or my preference, of course, would be for the Tennessee Supreme Court to take one of the Rule 11 applications that we are preparing to hopefully finally settle this debate that we've been having for a few months now about what the right to appeal in a probation revocation case actually means. Now, our position, as we've been saying in each of these cases, is that the right to appeal from a probation revocation order is meaningless unless that right includes appellate review of the consequence that is imposed by the trial court after it finds that a violation has occurred. And in these cases, essentially, we all know that the abuse of discretion standard applies, but because of an abuse of discretion has never been found by this court in the way that we are asking for it to be found in these cases, there seems to be a lack of guidance on what an abuse of discretion actually means in probation revocation. Again, our position.
Ms. Wingerter, is it going on? We have had these, and you've used the term right to appeal several times, and I understand that, but the statute gives the trial judge the right to reinstate the original sentence. How does this court, as an intermediate court, get around the clear language of the statute when the trial court fully revokes probation?
Yes, Your Honor. So we understand that the trial court has the right to pick from among several different options after a violation has occurred. But that is simply the definition of a discretionary decision. And I'd like to relate it to sentencing, because I think we all understand sentencing a bit better than probation revocation. So in sentencing, for example, a trial court has the right to pick a sentence length from within the applicable range. So if we have a range 1 offender who is convicted of a Class C felony, the range is 3 to 6 years. The trial court has the option or has the right to pick one of 4 lengths: a 3-year sentence, a 4-year sentence, a 5-year sentence, all the way up to a 6-year sentence. If the trial court picks one of those options, it is exercising its discretion under the statute. But that does not mean that this court simply affirms the trial court's decision without any analysis. What happens even after buys, the trial court still has to put findings on the record and has to explain why, within its options of 3 to 6 years, it picked 3, 4, 5, or 6. It has to put those findings on the record. Then this court on appeal looks at that and says, okay, trial court, you did your job. You looked at the pre-sentence report. You looked at the enhancement and mitigating factors. You considered the circumstances of the offense. Now we give you a presumption of reasonableness, and very likely that sentence is upheld on appeal. But that's not what has been happening in the probation revocation context. What is happening here is this court has said, trial court, so long as you pick full revocation, incarceration, reinstatement, or extension, one of the 4 options, you're good. We affirm without any analysis. And so what we are asking this court to do in the probation revocation context is to apply the same familiar abuse of discretion standard to which option the trial court selects. It can select incarceration, but our point is that the trial court still has to explain why incarceration over reinstatement or reinstatement with modification or some other community-based alternative is the conscientious and intelligent judgment, is the decision that is based on an assessment of the proof, is a decision that is not arbitrary, that is not capricious, and one that that serves the best interest of both the defendant and the public. And so far, we don't have cases where this court has gone through that analysis. There are a few over the last 2 decades. But in the majority of these cases, the court simply says, once the violation is found, trial court can pick any one of those options and we will affirm. And again, respectfully, Your Honors, that's just not how the abuse of discretion standard works. And the Tennessee Supreme Court has said that the abuse of discretion standard, even though it is less rigorous, it is a less rigorous level of appellate review, it still has meaning. And instead of reviewing these decisions, which the Tennessee Supreme Court in Lee Medical v. Beecher, that's what they talked about, was how to review these discretionary decisions, how to determine, did the trial court properly exercising its discretion in picking the option that it did? Instead, what we have in most of these cases is this court simply immunizing or insulating the trial court decision from any review at all, just because a violation has occurred. And so we're asking this court to not insulate or immunize the second part of that revocation decision, but instead actually apply the abuse of discretion standard to it. And I think Mr. Dagnan's case gives a very good example of just the basic traditional standard of abuse of discretion and how it can work in this context. Mr. Dagnan admittedly violated his probation when he did not report to jail after he was terminated from an inpatient rehab program he was in. We don't dispute that. He did not report afterwards. That's a violation. However, the circumstances surrounding this case all go to how the trial court exercised discretion in deciding to fully revoke Mr. Dagnan's probation and order him to serve the balance of a 6-year sentence for that failure to report. Number one, Mr. Dagnan, this is in the record, it is undisputed that Mr. Dagnan was wrongfully terminated from this inpatient treatment program that he was in. He never should have been kicked out of this program. It was a year-long program. It was designed to address his substance abuse issues, which were fueling, his addiction was fueling his criminal behavior. So he was in this program that would have addressed his issues. He gets kicked out by someone at the program who has since lost their job. I'm not sure if it was directly related to this incident, but the trial court made findings on the record that this particular program had administrative problems, and the trial court accredited the fact that Mr. Dagnan was wrongfully terminated from this program. But then the trial court said, I have no choice but to send you back to prison. Now, in some situations, that might be true, that prison is truly the only option. But here in the record, the director of this program told the trial court, number one, Mr. Dagnan should not have been kicked out. The person who kicked him out has been fired. He doesn't work here anymore. And we have re-accepted Mr. Dagnan into another one of our basically sister programs. It was a slightly different program, but it was still a year-long inpatient rehabilitation facility, which is what Mr. Dagnan should have been in all along, but was kicked out of through no fault of his own.
And so after he was kicked out of the program, he absconded.
That's correct, Your Honor. He did not report back to jail within 4 hours as required. That is the violation.
How long did it take him to report back to jail?
That is unclear. He was arrested. I believe it was several months later, but it's unclear whether it was, I think it was May or June, and the record's not clear on when exactly he was reported back.
So he never reported back to jail. The law enforcement arrested him.
That is correct, Your Honor. That is the violation.
And this was his 5th violation. He had already been revoked 4 previous times, correct?
That's correct.
Wasn't he located out of state when he was arrested?
I believe he was picked up in Georgia. Yes, Your Honor. And again, I can't dispute any of this. It's in the record. Our point is all of that simply goes to the violation itself. It does not go to the.
Are you arguing he did not violate his probation?
No, Your Honor. We're not arguing that. We're acknowledging that the failure to report within those 4 hours is a violation that was in the conditions of his probation. We're not disputing that. What we're saying is when the trial court had Mr. Dagnan back in front of the court to determine, okay, now what do I do about this violation? The trial court should have considered the evidence in the record that there was an available treatment program for Mr. Dagnan to be returned to that he should never have been kicked out of in the first place. That's what makes this different. I understand the violation occurred. I understand the violation is supported by evidence in the record. But if we apply the abuse of discretion standard to the second question, the consequence question, that requires the trial court to exercise a conscientious and intelligent judgment in deciding which one of these 4 options do I pick. And when the trial court has evidence in the record that the program wrongfully discharged Mr. Dagnan and is willing to take him back, when the trial court ignores that and says, I have no choice but to send you to prison, that is the abuse of discretion. That is a clearly erroneous assessment of the proof because the trial court did have an available choice. It is an arbitrary and capricious decision because it is not based on the circumstances of Mr. Dagnan being discharged or the fact that he had been reaccepted. And again, those are simply the definition of abuse of discretion. We're not asking for any kind of new standard to be applied.
What does any of that have to do with absconding from the state and having been and requiring the law enforcement officers to rearrest him months later?
To be quite honest, Your Honor, I don't think it has anything to do with that, because that is the violation. That is not the consequence. And those are two. This court has said that those are two separate exercises of discretion. This court has said, trial court, you can determine whether a violation occurred. That's what Your Honor is referring to with the absconding. And trial court, you get to determine what to do about it. That's where we're talking about the wrongful discharge and the fact that he had been reaccepted, and the trial court simply ignoring that evidence in the record.
Does the probation suspension procedure require that the trial court have a hearing on that second piece of what you're arguing here? Is the trial court required to have a hearing to determine how the balance of the sentence is served?
I am not sure, Your Honor, whether that is in the statute, but I can tell you.
I'm looking right at the statute, and I see nothing here that requires the trial court to have a hearing once a violation has been determined.
So in most, I think I can safely say that in all of the cases that our office has filed, there has been a hearing. And in the majority of these, the hearing has only focused on the consequence, because in most of these cases, the defendants actually concede the violation. Then they have a hearing on what to do about it. And the defense.
What authority is there that there even has to be a hearing? Is there authority?
I cannot point to any off the top of my head right now, Your Honor. I can only speak to the practice that trial courts employ.
Some do, some don't. Some do, some don't.
So, and in the ones that do not, I can't speak to those because those aren't the ones that we have filed these appeals in. But in the ones where a hearing is held and a trial court picks one of these statutory available options, it is exercising its discretion in picking an option. And our position is, if you can exercise your discretion, you can abuse your discretion. And so if a hearing is held on the consequence and the trial court ignores evidence that is put into the record about what the appropriate consequence should be, in our position, that's no different than in a sentencing hearing, a trial court ignoring the pre-sentence report or other evidence in the record in picking from among the range. For example, since we talked about sentencing earlier, if a trial court for that range 1 offender with a Class C felony with a range of 3 to 6, if a trial court said, I have no choice but to sentence you to 6 years, I don't think this court would ever affirm that finding without the trial court putting reasons for why the 6 years versus 3, 4, or 5 was appropriate. The presumption of reasonableness from Bias does not kick in until the trial court puts those findings on the record. And so here we're asking that it be addressed the same way. It's an abuse of discretion. The trial court has several options. And when it says, I have no choice but to order full incarceration, when in fact there is evidence in the record of other choices that the court has ignored, that can be held an abuse of discretion. And in Mr. Dagnan's case specifically, we have the trial court completely ignoring evidence in the record that he could have been reaccepted and that he had been reaccepted and could have been readmitted to this rehabilitation program.
Again, what does that have to do with absconding after being wrongfully, in your opinion, kicked out of the rehabilitation program?
It doesn't, Your Honor, because those are two separate questions to be answered by the trial court. That
has been the bulk of your argument, that he was wrongfully kicked out of this program and they would accept him back in. And, to me, that has nothing to do with the issue in this case. The issue is the absconding from lawful authority and having to be rearrested out of state months later. Now, if there's proof about why that happened, that might be relevant, but I don't see how being kicked out of this program is relevant to that issue at all.
Right. And I think we're saying the same thing, but sort of missing each other, because I agree with you that only has to do with whether he violated in the first place. Then as far as him being wrongfully discharged and being reaccepted to the program, that goes to the consequence of the trial court saying, I have no choice but to put you back on probation when there was a choice to readmit him to the program that he never should have been let out of in the first place. And so there's just two different parts of the analysis. And again, I think we've clearly made our argument, and not just in this case, but in multiple cases. And again, for Mr. Dagnan's in particular, I would ask this court to reverse and either order that he be reinstated to the rehabilitation program that was available, or at the very least remand for the trial court to consider that option, which it ignored at the revocation hearing. Thank you, Your Honors.
All right. Thank you, Counselor. You still have your 2 minutes rebuttal. Your rebuttal time is still available. General?
And please the court, Ben Ball on behalf of the state. I'm filling in for Clark Thornton today. We've had a number of these cases recently where we have an admitted probation violation and the trial court has ordered revocation. And the law is clear in these cases that where there is substantial evidence of a violation and an admission of a violation is substantial evidence, it is not an abuse of discretion to revoke probation. And as I understand it, there's the argument that the defendant is making here, and we've seen in the past, is essentially that because there is law that says there are separate exercises of discretion in determining a violation and in deciding whether to revoke, that there has to be an ability to abuse discretion in revoking. But the case law is clear that where there is substantial evidence of a violation, it is not an abuse of discretion to revoke.
That's not mean that a trial court. That's not what I hear the state arguing. I hear the state arguing the second piece, that there's an abuse of discretion standard placed on the trial court that we have to review to see if the defendant should have served his whole sentence. And I'm sorry, I just don't see it in the statute. Can you help me there?
I don't see it in the statute either. There is case law that says there's a separate exercise of discretion, but it also says that there is no abuse of discretion when there's a violation. And so the way I understand that is there would be an abuse of discretion if a trial court departed from the options that are available. And the trial court, say, extended the length of the defendant's sentence beyond, instead of just in putting in place, implementing that sentence.
Well, do you think the statute envisions a hearing on how the balance of the sentence should be served?
I think the statute envisions a hearing on whether there's a violation. I think you're
no question.
Right, Your Honor.
No question. I couldn't agree with you more. But is there a hearing required in a situation where the defendant comes in and admits I violated probation? Is a hearing required then?
I was looking at the statute when you brought that up, Your Honor. I don't see it. I never considered that before, but I don't see that requirement. And the defendant makes a comparison to sentencing here. And I think that comparison is not apt, because in sentencing, we have statutory factors that are required that a trial court has to look at. There are enhancement mitigating factors. There are factors you look at whether to grant probation or consecutive sentencing. Those same probation revocation is not set up the same way. The question is simply, was there a violation? If so, the trial court has a range of options. And it's not a violation to revoke when there is a substantial evidence of a violation here. And as Judge Holloway pointed out here, what we have is a defendant who is on his fifth violation who did not report back to jail as required. And not just within that 4-hour range, but he never reported back. He was later arrested.
I don't know that you need to spend your time arguing whether or not he violated probation. It sounds like the defense admits he violated probation. What I hear them arguing is the trial judge abused his discretion by requiring him to serve the balance of his sentence in prison.
That is their argument, but the case law is clear that it's not an abuse of discretion when there's substantial evidence of a violation to revoke. I think it's that simple. This court has repeatedly decided along those lines. I know that this summer we were here on a similar case, and Judge Williams pointed out this is so simple that he saw it as a Rule 20 situation. And as I recall, that case was decided in a memorandum opinion. I would hope this court wouldn't do that because it's it's beneficial to have something that we can cite to on this issue. But either way, the case law is clear that whether there's an admission, as long as there's substantial evidence of violation, it's not abuse of discretion. If there are no further questions, we've asked the trial court to affirm the judgment. Ask this court to affirm the judgment of the trial court. Thank you, Your Honors.
Yeah. Thank you. Thank you, General. Rebuttal, Counselor.
Thank you, Your Honor. Judge Easter, to your point, the state in its brief did acknowledge that there are two separate exercises of discretion here. So that the state is now saying that the trial court can never abuse its discretion is not the position taken in the brief. And I recognize Mr. Ball was not the author of that brief, but still it's the state's position in this case and in other cases we've had that there is a separate exercise of discretion, which is why the case law is not clear, contrary to the general's assertion. That is why we have continued to file these appeals. That is why we're filing Rule 11 applications, because there are at least 3 different approaches that this court has taken in these cases. In some, yes, as Judge Williams issued, that was my case, that was issued a Rule 20 memorandum opinion, because Judge Williams believes as long as there is a violation, trial court can never abuse its discretion, and we don't even look at that second part. That's one approach. Another approach that Judge Wiedemeyer has taken in his prior opinions is there are 2 separate exercises, and we will actually look at that second exercise of discretion, what the consequence is, how many violations the person has had, what the circumstances of the violation were. And the general's right. We don't have clear statutory guidance in probation revocation cases like we do in sentencing. But that's why these cases are so unclear that we are asking for this court's guidance. We are asking for the Supreme Court's guidance. And I just want to make one other point on the trial court departing from available options. If a trial court were to extend probation for, say, 4 years beyond the statutory maximum of 2, that's not an exercise of discretion because the trial court does not have discretion to do that. That is simply an error of law. That, to me, is like the trial court sentencing a defendant outside of their range. The trial court does not have the statutory authority to do that. Therefore, it is not an exercise of discretion and can't be an abuse of discretion. It's simply an error as a matter of law. The abuse of discretion has to be tied to the trial court's choice within its discretionary options. The options, if in sentencing, within the range, and the options in probation revocation ranging from incarceration to reinstatement or extension. And just as in sentencing, the trial court does not get that presumption of reasonableness unless it sentences within the range. Same thing here. A trial court would not be presumed reasonable if it revoked probation and imposed a consequence that it did not have the authority to impose. That's just totally different from an abuse of discretion standard. And unless the court has any further questions, again, we would ask this court to reverse and either reinstate to rehabilitation or remand to the trial court. Thank you.
And appreciate the argument. I appreciate the arguments for both sides. We'll take the case under advisement, and I'll ask the clerk, please, to adjourn court until our next case at 11 o'clock. Thank you.
This court is now in recess.